Good afternoon, everybody. I'm Nathan O'Lane, a partner in Husch Blackwell's Intellectual Property Group, and I want to thank everyone for joining us today. Welcome to our 2021 IP webinar series. In the past, we have hosted seminars in our local offices. However, this year we've transitioned to the webinar format. Today's webinar is going to focus on global patent protection and strategies that companies can employ in seeking protection outside of their home countries. A lot of our focus will be on U.S. companies seeking protection outside of the United States, and that's where our conversation will primarily center. We'll also talk about some updates in global patent laws, and our conversation will principally focus around patent procurement, not necessarily enforcement. However, since strategies relative to procurement can often impact enforcement, that will come into the conversation perhaps tangentially. As mentioned, this is kind of a new webinar format for us. Our next two webinars are already scheduled, that being for April and May. On April 20 at noon Central Time, Tara Ficken of our office will host a webinar focused on sweepstakes, promotions, contests, and giveaways. And on May 18th at noon again Central, Mike Annis is going to host a webinar focused on recent trends in false advertising. So just a few housekeeping items before we begin here. First, at the bottom of your audience console, there are multiple application icons. You should see them at the very bottom of your screen for your use today during the program. If you have any questions during our webcast, please submit them via the question box. We'll try to answer these questions today if we have time at the end, but to the extent that we don't have time, still submit them and we will make sure that we get that answered via email after the webinar. Second, throughout the program, we'll have a few poll questions. Now, no pressure because there's no right or wrong answers. These are poll questions that you can answer based on your experiences and based on your thoughts of global patent protection. Third, and maybe most important to some of you, this program has been improved for CLE, or Continuing Legal Education Hours. To report these hours, click on the CEU icon. You should see at the bottom of your screen the CEU icon. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of this webcast for watching and sharing. Finally, toward the end of the program, be sure to complete a survey. Again, I think this is in your console that you can see there. We use this feedback for future programming and would love your input on this program and what you may like to see in the future from us in terms of content that we can help provide. So that's it for the housekeeping items. Let's get started. So today we have a group of panelists with us, and it's my pleasure to be joined by this absolutely terrific group of panelists made up of patent practitioners throughout the world. Each of these patent practitioners is from leading firms. We have a relationship with each one of them, and I greatly appreciate them for taking time out of their day, and in Lucy's case, perhaps evening, to join us. So joining us today are Lucy Johnson, Patricio King, and Sumiko More. Lucy is a partner and European and UK patent attorney at HGF Limited. She heads up their engineering team and has extensive experience covering a broad spectrum of subject matter, from mechanical devices to water treatment systems to welding technologies, as well as automotive and oil and gas technologies. Welcome, Lucy.
Thank you, Nathan.
Patricio is a patent attorney with more than 15 years of patent experience and is a partner at Video & King, which is an intellectual property firm based in Mexico City. His professional practice includes assisting and advising clients on the creation, preservation, protection, and defense of inventions, utility models, industrial designs, and trade secrets, as well as other matters of IP and industrial property. Welcome, Patricio. And finally, Sumiko More. Sumiko is a partner at Gowling WLG, and is a registered patent agent in Ottawa, Canada. Sumiko focuses on patent prosecutions in various fields, including computers, mechanics, and materials. Previously, she practiced as a patent attorney in Japan. Welcome, Sumiko.
Thank you, Nathan.
Okay, so before we get started off on the panel discussion, we've got our first poll question. And I think the poll question should be on your screen soon, if it's not already there. There it is. How would you describe your level of experience in patent matters? I suspect that our audience today is varied widely, but we'll find out. Perhaps there are some folks here that are highly experienced in patent matters, in particular, global patent matters, and maybe others of us don't have as much experience. And so maybe so we can tailor our conversation today, it'd be helpful to know where everyone's experience lies. So I'll give just a few minutes here to answer the question before we move on. Okay, just a few more seconds here. If you haven't entered your answer in yet, do so now, and we will move on to the results. All right, so pretty wide variance, but it looks like a large number of our participants have a deal of experience in patent matters, so that's good. At the same time, we've got with a few here that maybe aren't as familiar. So we will certainly tailor our answers in the conversation so that it's applicable to everybody that is joining us today. And with that, we'll get kicked off with our first question. Lucy, I'll start with you. Can you briefly describe the patent prosecution process in the UK and or the EU, perhaps, and in particular, maybe a general timeline and any significant differences that may exist as compared to the US patent prosecution process?
Be glad to, Nathan. Thank you. And I will cover both the UK and Europe in this because there are slight differences with the UK perhaps being a little quicker and certainly having a fairly fixed timeline around examination phase compared to Europe. Over the years, we've known Europe take a long time to look at patent applications, and hopefully I can bring some good news for those of you still waiting for older European patent application to grant. So UK, Nathan, the search and examination is small fee, paid on filing, and we're talking about a few £100 to have an application in the UK searched and examined. So the big difference there on fees. You're going to get that report back 6 to 9 months after filing, so pretty good. And the UK search results are pretty good in most technology fields. There's some they're a little bit less good, but on the most part, you're going to get a good search. And if you request examination right off the bat, you're going to also get a decent examination report. So a fairly early view of patentability, certainly in good time for that 12-month date if you want to go beyond the country. So UK, known for a pretty good search and pretty early. It's going to go to grant within 4.5 years of that first filing. So that is a requirement in the UK. There is an acceptance deadline, 4.5 years from filing, or 12 months from the first exam report. And that's the get out of jail card for the examiners. If they take a long time to get there, they have also 12 months from the first examination report. So that's quite a useful timeline. And we have indicators now from the Patent Office about when they're going to get to that report. So we can give you a pretty good idea fairly quickly of what's going to happen in the UK. So they're the headlines on that score. The European Patent Office are trying to get better, Nathan, is the headline for today. They've come up with a new program, Innovators Need Early Certainty. And what does that mean? They're going to try and get to searches within 6 months of a filing. They are going to try and get to examination within 12 months of a filing now. And this, as I say, for those who've used the system for a long time, this is good news for those who want to get the patent through the system more quickly. The European Patent Office also has 3 examiners looking at acceptance or refusal. So as it gets to the end of the system, they have a voting system where they're going to look at novelty, inventive step, and other issues, and 3 examiners will have looked at that before it's accepted or refused. So the headline on that, fees are a bit more expensive. You can imagine that. It's a bigger office serving a lot more countries. So 38 countries currently covered by a European patent application. So it's going to be searched at 6 months, and they're trying to examine it within 12. We're typically seeing 3 to 4 years to a grant in Europe. So although it's examined within 12, it might kick around the system for a bit longer. They're pretty good on most subject matters. The biggest difference to the US is this technical effect they need on software and related inventions around computer inventions. But otherwise, we've got a pretty robust searching system at the EPO. So they like that. They like multiple dependencies. You and I have just worked on a case where you guys don't like those. We love them. So multiple dependencies are definitely allowed over here, and we'll use them to combine subject matter. You'll also know that the reason we do that, Nathan, is added subject matter is a big deal in Europe. And one of the biggest differences between the US and Europe is the scope with which you can use the description. The European examiners like to see it in black and white written on a page if we're going to use language for the claims. So we have far less scope to move. So although I smile when I say those multiple dependencies are important, so it gives us basis to make combinations that otherwise we aren't allowed to do. So probably the headline from Europe is that added subject matter still is important. When we're bringing specs between jurisdictions, we like to have those combinations set out in black and white for the examiner so we can lift them from the text. So in headline, they're getting better in Europe, they're getting quicker. You get a pretty good search and examination, but we still need that literal basis for anything we want to put in the claims. So they're the headlines from Europe and the UK.
Terrific. Thank you, Lucy. Patricio, I'll ask you the exact same question. Can you briefly describe the patent prosecution process in Mexico?
Yes.
And maybe a general timeline and any significant differences that as compared to the US?
Well, the general timeline for a patent to be granted is 4 years. There's a few cases that you can have a grant on 3.5 years. This is because all applications have to be published 18 months after the filing date. So you can't shorten that period unless you pay for an anticipated publication. You pay a basic fee, and the broader the text, the larger it is, you will have to pay an additional fee per page. This new form of fees entered into force about 3 years ago. In the past, Mexico was a more friendly country. We had a flat rate, so bigger inventions and more complex inventions just paid the same fee, and the office realized this was unfair and not profitable. So now foreign applicants have to be more careful, and it's more difficult to share an exact cost because the official language in Mexico is in Spanish, and when foreign attorneys send the specification text, it can turn maybe to be almost twice as long as in the original language. So really, the more expenses that will be you have to take care is the translation expenses. Other than that, I could say you can file an application and find a good attorneys, to manage your portfolio. From about 450 to 700 would be like the average rate for filing a patent application. The difference is in contrast with the US, we don't have provisional patent applications. We don't have continuation in part applications. We don't have any reinstatement procedures. So you have to be very careful of who your agent is in Mexico, because once an application is abandoned, it's almost impossible to reinstate the case. Also, an important difference is in the subject matter. No, computer programs are typically refused when they are claimed only as a computer program, but more and more they are being accepted if they have some sort of technical effect or they are associated with a device. And those are, I think, the most important differences between the US. And I would say that all the documents that accompany the application, powers of attorney, transfer of rights, they have to be drafted according to the Mexican law. And they have to be bilingual. For example, a transfer of rights in other countries will be accepted just with the signature of the inventors, but the Mexican Patent Office will require also the assignee and the assigner signature in the document, which is not really common. So in order to surpass the formal exam, you must prepare these documents carefully. Once you get to the final examination, which is issued around year 3, this would be 36 to 40 months. You have only 4 final examination actions, 4 opportunities to overcome any objection during the final examination. And you have, once the case is granted, you have also a deadline to pay the fee. And even though you get a notice of allowance, if you don't pay the granting fee sometime, the case can still be abandoned. Mexico relies in the work products of other foreign offices, like the European offices, like the US office. So you can speed up the final examination, entering a program that it has been in place for about 10 years with the US office, the Patent Prosecution Highway. In January of last year, Mexico and the USPTO announced an improved program of the PPH, which is only in benefit of US applicants. If you have a US priority in Mexico, you can enter this program and you can fast track the grant of your case. For you to get an idea, 20 years ago, the Patent Office had only about 10 examiners for the whole country. Now the office is bigger, but not so much. It has 70 examiners. So I think sharing with you this number can give you an idea of why we rely so much on other offices' work, because of the size of the office. And since summer of last year, you can you can do electronic filings through a website that was implemented for the Patent Office. And we recommend to use this mean from time to time, because it has not been perfectioned. And sometimes when there is a long text, it's difficult to upload the file to the system. So it is you cannot rely on that electronic filing system yet, but it will be perfected in time. I think I have covered most of the differences, and perhaps I would like to underline the last one, which is we have a different figure besides than patents. It's called utility model, which is like a small patent, and it has a lifespan of 15 years. And it's for inventions related to mechanical devices and combinations of the same. And you only, and that creation, they only need to have novelty and industrial application. So they are much more easier to get. And if you filed a patent application and you cannot, and you have overcome novelty, but there's are problems with inventive step, you can step down from your filing and still get some kind of protection, which will be good for 15 years. So it is a good alternative to keep in mind also.
Thank you, Patricio. That's some good insight there. Samiko, I'll ask you the exact same question. In Canada, tell us a little bit about the patent prosecution process, maybe a general timeline, and any differences as compared to the United States.
I'm happy to. So if you file an application in Canada and it's meet the basic requirement, the patent office will give you a filing number and filing date. Sorry, the serial number. The waiting time for serial number is about 6 weeks from filing. And the application is published 18 months after the filing date or priority date, if priority was claimed. And the examination can be requested within 4 years from the filing date. This request can be filed by anyone. If a formal request is filed, the examiner will be assigned and the examination will begin. And then during the examination stage, office action may be issued. The waiting time for first office action is about 14 months from the requesting examination. And the final actions are uncommon, not usual. But if the final action is issued, you still can reply to the final in the same manner as those for non-final action. And you reply to the final action doesn't overcome the issues raised in the final action, and then the examiner maintains the rejection. The Patent Appeal Board will review the application. After review the process, this review process, the Patent Office sends the final edition to the applicant. The waiting time for a final edition is about 2.5 to 3 years after application has been transferred to the Patent Appeal Board. If a notice of allowance is issued, and then you timely pay the final fee, a patent is granted. It takes an average of 31 months from the requesting examination to get the patent. If you request withdrawable allowance before paying the fee, the application can go back to the examination. And this is a very simple process. Now I'm talking about the huge difference between the Canadian and the US patent prosecution. The first one is, as mentioned, in Canada, examination can be deferred up to 4 years from the filing date. So you don't need to pay the examination fee at filing. Also in Canada, there are no claims fees and there is no limit to the number of claims. So sometimes you can see the 100, 200 claims in one application, and the examination has the obligation to review all the claims. This is very important in Canada because we don't have a continuation practice, and filing divisional is really risky in Canada because of due to double patenting. We don't have the terminal disclaimers here, so there is a risk that will be an attack of double patent in court. Also, during the prosecution stage, the examiner sometimes say that, oh, this is double patenting. So you have to be cautious. And the other thing is about the examination process is quite different. As I mentioned before, the Canadian examiner usually issues non-final as long as the prosecution is advanced. And the examiner usually indicates in office action that a final action is to be expected if nothing happened in the then see the reply to this office action. So pretty much you don't see finals in Canada. And if examiner considers application will not amend to the objection and they reach an impasse, then examiner will reject the application and notify the applicant in the final. If the reply to the final action doesn't overcome the examiner's issue, like rejection, then your application is transferred to the Patent Appeal Board. I think this process is different. The Patent Appeal Board contacts you and asks if you are interested in continued review by the Patent Appeal Board or not. If you answer yes, then Patent Appeal Board will provide a preliminary review and you will have an opportunity to respond. And this process has no government fee, so there's no government fee involved in this process. So I said we don't have a continuation, CIP, and provisional application, and Divisional is available, but maybe have a risk of attacks for double patenting. So, and I said that there's no claim fee. So it's important to include all the claims, all the different scope claims, everything in one application. This is the practice in Canada. So back to Nathan.
Okay, thank you, Sumiko. Appreciate that. We're going to move on to our next question. This relates to updates that have happened over the last few years or months, perhaps, in the various countries and jurisdictions that everybody works in. Lucy, I'm going to turn to you first. Can you tell us about any updates that have happened? And I know that everyone hears Brexit all the time, and maybe tell us a little bit about what impact, if any, Brexit had on the prosecution process in the UK versus the EU, and maybe even talk a little about trademarks if you want to. Not that we want to get too far offline here, but perhaps that would be helpful in the explanation of the real impact of Brexit.
Absolutely, Nathan, thank you. And I'll speak on trademarks as any patent attorney would. So I know Rajesh has asked us a question today as well about Brexit. I mean, the key thing, Nathan, is the UK IP rights are not affected by Brexit to the extent they existed at 1st or 31st December 2020. So UK national IP rights are not affected. Patent attorneys can relax. The European patent attorney is not a European Union institution, so patents are not affected by Brexit at all. So no change for patent attorneys. The changes we touched upon there comes in registered designs and in trademarks. And anything that was on the European register, so European community trademarks, European registered designs, were cloned as UK rights if they were granted at the 31st of December 2020. So they will have been cloned, and the same right will have been created on the UK register by virtue of that clone. Now, the thing to take care of course, is those two rights are then independently renewable. So the one thing we have to take care of is they are then two standalone rights. If a right was pending in Europe at the time of transition, you will get the option to convert that into a UK right. So there's a choice to be made there. So you don't have to, but you can. So anything that was granted was cloned, but be careful because we now have two separate rights. Anything that was pending, we have a choice to make within a time frame. So Brexit did create a little bit of excitement amongst the trademark and registered design community, but amongst the patent attorneys, we were relatively relaxed about it, Nathan. So the big change in Brexit came for my trademark colleagues. So that's the big one. The other thing that's going on at the EPO at the moment, Nathan, I'll touch upon it. Happy to talk more about Brexit if and as required. But the EPO are looking very closely at the moment at the conformity of description to granted claims. And this sounds like a nothing statement. It doesn't sound like a big deal, but actually it's creating some waves because, as you know, granted claims can be very different in scope to the text of the description. And what the European Patent Office are asking at the moment is for us to take a lot of time and a lot of energy to take out anything that isn't covered in the scope of the claims. And we're pushing back quite hard as attorneys on that because it can be quite difficult to extract certain subject matter. So you might see that if you have European applications, you might see your attorney giving you some more advice around that conformity of claims to description. So of course, Brexit is the big headline, but the one that's causing the waves in prosecution at the moment and some consternation amongst patent attorneys trying to conform description to claims at the point of intention to grant. So that's really the big one that's happening. I know we've got some more questions as we go, Nathan, but I'll pick them up as we go through the question phase. But I think the Brexit one, I'm hoping Rajesh have answered.
Thank you, Lucy. Yes, we have some good questions coming in here. Some of them are actually very relevant to our discussion that we've got coming up. So those will dovetail nicely. I'm going to jump over. Sumiko, tell us about any updates that we should be aware of in Canada.
Yes, there are a couple of things. In 2020, the Federal Court made a decision about claim construction of pending applications. And then the decision said Patent Office made a wrong claim construction and should be follow the leading guidance by the Supreme Court of Canada. So according to that decision, the Patent Office issued a new notice indicating how to assess the patentability of subject matter. So this is very new, and this new notice indicates that they have to claim construction in accordance with the Supreme Court. That's a good sign, but still there's unknown definition in the notice. It said that actual invention. So we don't know what actual invention means. So we have to see how the Patent Office implement this new notice and see how they assess the patentability of the claims. So always it's a little bit different from 101 in US, but always I think the Patent Office try to push their own way. And the court rejected initially, now back to the Patent Office. So we need to see how it's going. And then the bright side is the case before the Federal Court was back to Patent Office, and the Patent Appeal Board actually allowed the case. So the case is related to the computer-related method for the managing a portfolio, and including some algorithm. And the Patent Appeal Board recognized that that algorithm speed up the processing performance better. So I think that's the key. How not only computer to the combination the algorithm make how the processing better or save energy or something that would help to overcome that assessment of the patentability. So in the practice, probably better to include those advantages in the application at first, or some evidence given from the expert to put into the Patent Office. And also one thing that's important is through the claim construction, we need to see the inventor's intent. So if something, the term like optional, then that means, computer is optional. It's not essential. So then probably patent office will ignore that element. So if that computer element algorithm is very, very important, then do not say the optional.
Very good.
Yes.
Very good. Very good. All right, Patricio, I'll turn to you. I know that you had alluded to some things in your initial answer regarding to the agreement between the United States and Mexico, but are there any other updates we should be aware of, or do you want to expand on that a little bit?
Well, yes, I think the USMCA brought a full reform of the intellectual property law. In fact, since the 5th of November of 2020, the intellectual property law is now called Federal Intellectual Property Law. And there are new dispositions in place. Some are very helpful for applicants, and some others not so much. I would say that the most helpful is related to claiming priorities. You don't have to send any more a hard copy on paper. You can just claim the priority providing the access code, digital access code, which was accepted on November 18 of last year. That is very helpful. For looking to third parties or technology watch, the good news is now the process of patents, designs, and utility models is open. That means that once the application has surpassed the formal exam and the application is published, any party, any person, any interest that you want to review the case and prepare maybe a right of opposition, you have 2 months to file an opposition or evidence against the granting of an invention which you consider should not be allowed. That could not be done in the past because all the process was considered confidential. So you could not, you could only infer because of the time of filing that something went wrong with an application of a competitor, but you would not be certain that the case could be abandoned. So really, non-infringement reports could not be exact. The not so fun part is there have been changes on divisional applications. Okay. In Mexico, we used divisionals because it was the legislation was so open and there were no restrictions to filing divisionals that we could use divisionals for to start like a continuation in part process. If you had no more chances in the final examination, you could, and the strategy would be to file a divisional. So then you would start from the fourth action of the parent case. And that was very useful because you could have like legal patent creativity to try to create the scenarios that were available in other countries. You could even file divisionals after a case was granted, but now voluntary divisionals, you have to be very, very careful because you can only file them before you pay the granting fees, and you have only 2 months to file as any divisional that you want to file before 2 months have passed from receiving the notice of allowance. Okay, so once that period is expired, the divisional will not be accepted. There are now dispositions for the final examination division to look up very closely for divisional filings. You cannot file a divisional from a divisional. So I think this this particular new set of rules are unfavorable. We'll see how this plays. There are new scenarios for patent annulments, which are related to prosecution and enforcement. In the past, there could be big mistakes on the granting of a case, and you were only allowed to file an annulment claim if you did 5 years from the granting date. Now, all the presumptions have no time limit, so you can attack a patent for the reasons set in the law without any time limit. Second, medical uses are now specifically allowed. There is a statement saying that known compositions which have new uses can be patentable, and our law is now expressly allowed the clause for Ebola exemption, which you should probably know is a limitation to the patent right, where an entity can start experimentation and fabrication of a pharmaceutical compound if they are not going to use it in commerce, but they are trying to obtain a sanitary authorization. That was not included in the previous law. And pharmaceutical companies will be, that used to file a lot of patents are not that happy with this exemption, but they have in the USMCA a disposition for data protection, that information and exams and results used for safety of pharmaceutical compound submitted to the sanitary authority, they are considered confidential and no one else can use the same results. So even though the generic companies got with this Ebola exemption, at least the data protection will help to even this field. And I think the most important adjustment is the complementary certificate, which is the adjustment of the validity of a patent. In the past, if there was an unreasonable delay by the Mexican office, well, you could only complain, but there was really no legal remedy. Now, if during the prosecution you see that it has taken more than 5 years for the issue of the notice of allowance, when you pay the granting fees at the same time, but in a separate document, you can file a petition to adjust the validity of a patent, and you will get, for every 2 days of delay, the office will pay you back 1 day. The exact text is probably going to be challenged and perfected within time, because the issue lies in what is an unreasonable delay, because there's an exception that the patent office put in place in the law saying that they don't want to be responsible, or they are not responsible for delays that you have to challenge in appeals. And really, when you go to an appeal, it's because of the patent's office fault. No, if there's a delay, if there's a mistake during the prosecution, the only remedy that you have is going to another authority. And because we have written processes, it will take at least 2 years that you want to get back. So probably this will be adjusted in the future. Industrial designs, which are equivalent to patent designs, and utility models, both are now published. They don't comply with the 18-month period. The law states they will be published as soon as possible, no? Whatever that could mean. And they have, the utility models are now valid for 15 years, and industrial designs are valid for 25 years. Okay, so I think those are the most important updates in Mexican patent prosecution.
Sure. Thank you, Patricio. Okay, we're going to turn now to our second poll question. And this poll question should populate on your screen here shortly, hopefully. And here we go. Okay, this is a pretty easy one. Does your organization currently file patent applications outside of the United States? That's the question. Does your organization currently file patent applications outside of the United States? We'll give it just a few minutes here, just a few more seconds here, rather, to populate and see what the results are. All right, it looks like the vast majority, 78% about, file applications outside of the United States. And I'm assuming that based on our attendance, most of the folks, but not everybody, is based in the United States. I know we have several folks who are European based or elsewhere throughout the world joining us today. So that may have an impact on that number, but 78% file outside the US. So relevant discussion for everybody here. All right, we have a question that's come in, and it actually dovetails nicely into the next part of our conversation here. The question that has come in, one of the questions that have come in, if you already have filed a PCT application, will the process be faster? So for each of the panelists, let's answer that. And if there are any differences that we should be aware of, significant differences, let's say, that we should be aware of versus the strategy of filing directly. And let's say, for example, we have a US-based company and they filed a US application. And within the 12-month time frame, they have the choice to either file a PCT application or they may file directly into your country. Is there a big difference there in terms of timing and strategy? So I'll, Lucy, it looks like you're up and ready to answer. So I'll turn this to you.
Yeah, no problem, Nathan. And I know we come on later to whether we can speed things up and slow things down. And this might be highly relevant, particularly to Brad's question. If you've already filed a PCT application, the big difference between going directly into Europe and going through the PCT is timing. And also at the back end of a PCT, going through the European route or going directly into the UK, for example, this is all about time frame, Nathan. So if you go US, PCT, Europe, UK, that's a much longer timeline than if you go US, UK, and simply the time taken through the office. You can control that timeline, but generally speaking, it's going to be longer through the PCT. Brad's question, he's already filed one. He can drop out of the PCT into Europe at any stage while that PCT is pending. The European Patent Office will wait for the international search report before they search it themselves. But other than that, you can drop in early. So even if you filed a PCT, if you have cause to go into Europe or the UK early, you can do so at any time. with independency of that PCT. So the key thing here is timing. Also, Nathan, some of the jurisdictions in Europe, so you can file a European patent application, but you can file national applications, either direct from your US and claim priority. The key thing to remember with the PCT is not all national routes are open. So some jurisdictions ask you to go through the European route to get back to the national route. So the UK is not one of them. You can go PCT UK, but there are some significant countries where you can't go PCT national. You have to go PCT Europe. So if timing is an issue, this is something that you really do need to consider. Once you've dropped out of the PCT, you have to go through the search and examination phase. So both of these do take time. So the main thing between direct and PCT and then in is timing, Nathan. So there are things you can do, and I know we come on to this, there's things you can do to speed that up, or potentially in Europe slow it down, but that's a discussion we'll come on to. But timing is the main one. And as I say, just being careful that PCT national routes for some European countries are closed. You can't do it that way. So you'd be forced to the EPO and the European route if you weren't aware of those.
Very good. Thank you. So Miko, is there any difference in Canada, filing directly into Canada versus coming in on a national phase application or national stage application through the PCT route?
Okay. At the beginning, direct filing application only needs a 3-element indication that the application is seeking a patent and the identity of the applicant and the contact information. Also, a document in any language that appears to be a description. If you file this 3 elements, the filing day is established. And comparing to this process, if you file a national stage application in Canada, you have to provide all the requirements, including the translation and also fee, basic fee. So if you really need to file immediately and you don't need a translation, then the filing, direct filing is the key. And if you have a time, then national entry. And then during the examination stage, Canadian examiner typically consider available foreign search result. That means for national stage of a PCT application, first office action usually refers to the International Preliminary Report on Patentability, IPRP. So that was issued during the international stage. So that means you have 30 months and came into Canada, and then if you immediately file a request for examination, and still 40 months to reply to the office action at the average, and then you will see the same result from the PCT. And then usually the examiner say, the IPRP, that is the international stage product, is relevant. So that means Canadian claims do not comply with the Patent Act. So that's the first office action. So think about that. If you have a time and consider the claims, the PCT national entry would have more time to consider to structure tailor your claim. But you need to file quickly, then of course the direct filing is a key.
Very good. Yeah, a lot about timing here. A lot about timing. Patricio, filing direct into Mexico versus coming in as a national phase application through the PCT. Any big difference there that you want to point out?
Well, I think the differences would be that no other countries have it easier in Mexico because of the geographical relation with the states than U.S. applicants or inventors. The average time of grant for a U.S. application is a lot faster than any other kind of application. We have the patent prosecution highway. So we don't have any, you cannot fast track the exam. You cannot pay a fee for an advanced examination. The closest thing that we have is the patent prosecution highway, which is both available for US filings and for PCT filings. I would say the main differences, as Lucy pointed out, is if your application is coming from a PCT filing, you will be probably be entering close to the 30-month deadline. No, at least that is the purpose of the PCT. So 30 months is almost about as close to 3 years. No, that could be done in a direct filing. You can file in the States today, and 2 or 3 months later file in Mexico. So a direct filing will always be, you will always get to a grant or to the final examination sooner than a PCT filing. The benefits of the PCT is sometimes Mexico is not the applicant's first choice to exploit their invention. And we usually use the PCT when we want maybe up to 4 or more markets where you want to protect the invention. But if you're only interested in Mexico, I would, or two, or maybe Mexico and Canada, I will choose the direct filing. The benefit of using the PCT is once you have filed the application, is the filing fee in Mexico would be less than half the fee of a direct filing. You won't have to submit a transfer of rights. You won't have to submit the DAS code. You won't have to submit the priority document. So the PCT has like, helps you jump the formal exam, and it's easier for a PCT application to fulfill the formal exam than it is for a direct filing, because in both cases you will require the Spanish translation of the specification. Something that is not commonly underlined is that a favorable written opinion or a favorable international preliminary examination can get you to use the PCT patent prosecution highway. So you can also access a final result earlier. I was also reading. There's this year there's going to be a new process between Mexico and the U.S. In benefit of U.S. applicants called Parallel Patent Grant Initiative. Currently, the Mexican office has a small department that will take care of all the petitions for the patent prosecution highway. But this Parallel Patent Grant Initiative is for every examiner. The intention is for every examiner of every area to participate in this program and use the work products of the U.S. office. And it should end in being faster than the PPH. This is only available for U.S. file it first applications.
Okay, very good. You've actually, Patricio, answered the next question, which is one that we've had come in here regarding PPH. So thanks for that. I know we're running up against the hour here, but I do want to quickly ask Sumiko and Lucy that same question regarding patent prosecution highway. Is there any availability of accelerated examination, for example, the PPH, in your individual countries, and under what circumstances? Sumiko, I'll let you answer that real quick, and then Lucy, and then we will wrap things up.
Yes, Yeah, and accelerated examination opportunity are available through PPH and advanced examination under special order and advanced examination for green technology. Typically, the first officer action can be expected within 3 months. And then subsequent to any communication is processed as quickly as possible. And the PPH is always you need to file before the first officer action is issued. And the claim must be substantially correspond to the allowed claim for the product. But there's no fee involved. And then by contrast, advanced examination for the special order and for green technology, those can be requested at any time during prosecution by anybody. And for the special order, there's no special requirement regarding claims. For green technology, also there's no limitation of the claims, but the green technology should be related to green technology. Related to the green technology, and if the commercialized, then that will be help to solve environment problem or impact. And the interesting thing is, for green technology related advanced examination, there's no fee. You don't need to pay any fee. So if you want to accelerate the examination and you want to have some claims, but that claims including those not be allowed, but still you want to accelerate the examination, then the special order or green technology a choice. And the green technology, then you don't need to pay any government fee.
All right, very good. Lucy, I know you and I have talked about PPH in the past and different strategies. What are your thoughts?
We have, and I'll do it quite quickly, the PPH is available. In Europe, I would recommend something called the PACE, the PACE scheme instead. The PPH is available, but it's not as favorably looked upon as the Europeans' own, the European Patent Office's own system of PACE. So that accelerates examination of the application. So I would recommend PACE over PPH in Europe. In the UK, we can accelerate through a green channel, very similar to Canada. We can also accelerate for commercial or potential infringement reasons, and we can be pretty liberal with that. So if you want to go quickly in the UK, we can pretty much for many commercial reasons, for example, potential licensing or potential infringement out there, that we can go quickly for any number of reasons. Green channel is one of them, but certainly not the only one. And a bit like Sumiko, you can go very quickly from that point. So it's a number of months as opposed to years in that. So, and there's no fee in the UK, so you can request that we go quickly. The EPO are kicking around the idea of deferring and going 3 tracks, Nathan. Normal, quickly, and slowly. That's a bit of it's in the ether, it's not been written down yet. They've certainly consulted on it. They've looked at this before of a slow track. They haven't gone that way formally yet, but watch this space.
Very good. Thanks, Lucy. We could continue to talk about global patent protection probably for another, probably for the rest of the afternoon, but we'll respect everybody's time here. And I know we've already run over, so I apologize for that. Thank you so much to our panelists today for joining us. I know that you have taken time out of your day to do this, and certainly appreciate that. And thanks for all of our audience for joining today as well. We hope that you found this webinar to be helpful. There are a few questions that have come in, several in fact that have come in. We just didn't have a chance to answer. Patricio, one for you. Lucy, there's one regarding the EU that we will get to and answer directly offline here when the program wraps up. As a reminder, this webinar has been approved for continuing legal education, or CLE hours. To report that, click on the CEU icon at the bottom of the screen. The certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with the recording of the program. Also, one final note, please be sure to complete the short survey. We really want your feedback and what we can do to help support you and your organization moving forward. With that, that concludes our webinar. Thanks again, everybody. Have a great afternoon, or in some cases, great evening, depending upon where you're at. Bye-bye.
Thank you, Nathan. Good evening.